Okay, let's get started. Once again, welcome and thanks for joining today's session, Real Life Examples of How Probate Cash Can Help You and Your Clients, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. Mark will address questions after the presentation. If your question is case-specific or confidential, please indicate that in the chat and someone will respond separately after the presentation. Our presenter today is a professional with extensive experience in the probate field. Marc Harris is an attorney admitted to the Florida Bar and Southern District of Florida. Marc is also a member of Florida's Bar's Real Property, Probate, and Trust Law section. Marc has been working in the specialty finance industry for over 25 years, involved in purchasing over $100 million worth of assets. So most of his purchases are pursuant to various state laws, require court hearings, many of which Marc has either attended or appeared as counsel. And as the CEO of ProbateCash, Marc is now spearheading a relatively new industry of purchasing interest in actively pending inheritance claims from estates or trusts. Okay, so now without further ado, let's hear from Marc. Marc, can you start us off with what ProbateCash does?
Yes, and thank you, Molly, and good afternoon to everyone. We have mostly lawyers and paralegals from throughout the country here, and some note takers apparently also.
Mhm.
Love the technology. So what does Probate Cash do? Probate Cash provides advances to beneficiaries of estates who are waiting for their inheritance tied up in probate. So folks who want or are expecting an anticipated inheritance, we know that they can't get it until the court says, okay, the distribution of assets can be ordered. That takes a while. I've spent much of my career providing liquidity to people who are entitled to future cash flows, but don't have the ability to access that cash at the present time. So I think most people on this webinar can attest to and have likely fielded repeated phone calls from frustrated heirs, clients, that access to an inheritance falls neatly into such a category. With my background of providing upfront money for litigation cases to litigation funding, plaintiffs to money to plaintiffs. I have a lot of friends who are probate lawyers also. And they said, why doesn't that work? We get bombarded by calls, and even sometimes it'd be great to get paid up front for my clients who can't afford to or are waiting for their inheritance. So that's how this really got started. Um, how does this really start off? People usually are unfamiliar with probate. At least most of our customers probably never heard of probate, other than what they've seen on TV after someone's passed away. So after the loved one's passed away, the family gathers in the lawyer's office for the reading of the will. Oftentimes there's not a will, and the family members hear that they're getting their homes, mansions, money, cars, whatever it may be, and then the jaded people walk away with nothing. Case
Mhm.
closed. So we all know that's not how it really works, of course. So what does happen is people go to the bank and try to access the decedent's bank account, mom and dad's bank account, and the bank says you can't do that. It's not yours. You need to have something called letters testamentary, something they've never heard of. You have to open up a probate case. Same thing when they're trying to sell a house. So then they could call you guys up. You're probably doing marketing as well. They call you up, and now they're learning for the first time about probate and how long it takes. And then reality is now rearing its ugly head. Property taxes have to be paid, repairs made on the house, bills are coming in, beneficiaries who are counting on their inheritance to meet necessary financial obligations can't do so. That's the void that probate cash fills. So we provide a portion of the heir's inheritance with a non-recourse upfront advance and wait until the assets can be distributed before we're repaid.
Okay, but how does an advance from probate cash actually work?
Sure. So when we get a phone call, usually people are soliciting us. Most people find us through like they find you, Googling or word of mouth. We have a lot of referrals from attorneys, from realtors, and just folks checking out saying, how do I access my inheritance? So they contact us, or we'll talk with you as an attorney or paralegal who is representing the estate. We have a very simple application form just so we know if the estate has been, whether the probate has been opened up yet, and what jurisdiction it's in, so we can look it up. And then we have underwriters, just like you would have in most cases, determining whether to provide somebody with money up front. We review the case, see what stage the probate case is in, try to determine what the heir is going to be receiving, and the assets, of course. That's the how we're going to determine what the heir's percentage is. Um, then the goal of the advance is really to provide some necessary liquidity to a beneficiary, but also while keeping the beneficiary engaged in seeing the probate case closed. So we don't want to, and nor do we, purchase the entire inheritance. And in fact, depending on the status of the probate case, we may only purchase a small portion of the inheritance, especially earlier. So for example, if the claims period hasn't expired or if there's litigation, we'll provide a pretty modest advance. If the case is a final distribution and we have a really good idea of what the heir will be receiving, we can make a much larger advance. And a lot of it is geared towards, of course, what the beneficiary, but what the needs are for the beneficiary, what the needs may be for the estate as well. Our average advance is really just over $10,000. We've done advances as small as $3,000 and as large as advances that exceed $500,000.
I know you've mentioned that funding in advance, you can fund in advance in 1 to 2 business days. How could Probate Cash fund in advance so quickly?
Yeah, so I've explained what ProbateCash does. I hope I have, but let me explain what we do not and who we're not. We're not a lender, which is why we can fund advances very quickly. We don't charge an interest rate. We don't do credit checks. We don't take collateral. Moreover, if the heir cannot repay the advance due to an insufficient inheritance, we're the ones who will be shortchanged. That's our risk. If a will is challenged, that's our risk. If creditor claims wipe out the inheritance or reduce it so there's insufficient money to pay us back, also our risk. The only time that we have recourse is if the beneficiary materially breaches our contract, committing fraud, for instance, receives the inheritance and doesn't repay us. That's just stealing. So we're just looking really again at the heir's percentage of the anticipated inheritance and what are the assets that we think are going to be paid. So real property is a big deal, as you guys know as well on this call, is the primary asset that's being sold to get money to the beneficiaries.
Okay, now circling back to the title of this webinar, what are some real life examples of how Probate Cash can help lawyers and their clients?
So starting with lawyers and their clients, let's start at the very beginning of a probate case. You're getting a phone call. Now, in some states, if you're in California, you're probably getting paid at the end of the process as well. I think there's some statutory language on that. And in other states, you can get paid and you should get paid at the beginning, and you get a retainer like a more traditional client would. The people that are calling you are the ones we just described a lot of the time, and they don't have the ability to give you a retainer. And so, right off the bat, what we're looking at is if there is real estate that's going to be sold as part of the estate, or even if it's homesteaded in states that have homestead, uh, we will look at then advancing money to the person who is talking to you and wants you to represent them to open up the probate case, and we can advance them money for the purpose of paying you attorney fees for the probate case. So that's step one, is just to get things started and also get lawyers paid who are spending money on their marketing dollars. You don't want to turn anybody down because they can't afford to pay a retainer to. Second is now they've signed up with you and they're learning how long probate is going to be. Now, we know that you represent the personal representative or the proposed personal representative, so you may not be talking to the beneficiaries, other beneficiaries of the estate, but as we know, they're probably looking to call you. And they want to know, why is this taking so long? How come, when am I going to get paid? Our service kind of quiets that down. It gives everybody time to breathe. We can help them get through the months it takes to get the probate completed. And also it brings besides relieving pressure on you, the law firm, it relieves pressure on the personal representative who's also fielding those calls from usually family members or other beneficiaries. Those are two very practical issues. Then third is the estate itself, which will help the beneficiaries. So many of these homes that are going to be sold that are the primary asset of the estate are older homes, but they're in nice areas in Northern California that were purchased 40 years ago for $200,000-300,000, but today they're now over $1 million, or they should be, but they may not be in great condition. They have a lot of work that needs to be done to get fair market value. They may have property taxes in arrears and other issues that need to be paid off. And if that doesn't happen, or the personal representative feels pressured by the beneficiaries, the personal representative is going to be more likely to feel forced to sell the home to somebody like a cash buyer and not get the fair market value, which helps nobody. It doesn't even help you as the attorney, of course, if you're getting paid based on the assets of the estate.
Okay, now with a quick Google search, I saw that you guys have over 400 plus five-star reviews. So there must be countless stories of how you've helped real people. And do you want to share any of why your reputation is so good?
Well, I wouldn't say countless. I could probably count them, but we do
Mhm.
have a lot of good reviews, and we take pride in that. It's important because well, you guys also, besides lawyers and paralegals, you're running a business, and that's what our consumers are looking at, are reviews. As you mentioned, I am an attorney. My wife is an attorney. She does all family law, which is a lot of people know, kind of a cousin of the probate world, and we know how important it is to make lawyers, especially paralegals, the law office, look very professional to their clients, the beneficiaries. And we have our representatives who work here, besides underwriters who are paralegals in our office. Our underwriters have great empathy for our customers who we know need cash, need money. They are angry that the process is taking long. They want to blame somebody, and we're very careful to just keep everybody on track. We do not say, "Oh, it's your lawyer or the estate's lawyer." We don't want them calling you and being upset. I know how that happens. That doesn't benefit anybody, and so that's why I get the reviews. Is we're understanding, we're professional, and we're transparent.
Okay, that's great. Now, go back to beneficiaries. How does an advance to one beneficiary affect other beneficiaries who are not assigning portions of their inheritance? Also, how does an advance affect the probate case itself?
Okay, so of course, there are oftentimes multiple beneficiaries to the estate, and maybe only one beneficiary needs an advance for their financial needs. Uh, Probate cash enters into a contract only with the beneficiary who needs money. So we're only in contract privity just with that beneficiary. We are not in contract privity whatsoever with a personal representative or with you at the law firm at all. As I said, if there's a shortage in a shortfall in the inheritance, that's our risk. So if somebody owes us $50,000 at the end of the day, but they're getting paid 30,000 at the end of the day for their inheritance, we'll get the 30 and we'll be shortchanged on the 20. We do not look to the estate or other beneficiaries for that shortfall. We're not a creditor. We're not a creditor of the estate. We're just in contract with the beneficiary. Um, we want to be paid out of the distribution of the assets. So we want the personal representative to honor the assignment. And let me go back to that. When we make an advance to somebody, we they sign a document that we file in court, in the probate court, and that's an assignment of their inheritance or a portion of their inheritance. So if they're assigning, for instance, $50,000 of their inheritance, that is actually filed in the probate court. So all the interested parties have notice of it. The personal representative is aware of it, and you as the lawyers will be aware of it. Before we make an advance to a beneficiary, we do put a call or two into the law firm that's representing the estate, just so we can make sure that you're aware of what's going to happen, that there's going to be this assignment that is going to be filed, and so you're not caught off guard. We'll probably ask you if you anticipate any claims or any other issues that the files don't show yet in the public records. Just want to make sure that you're on board. What we find at the end of the day is the more transparent everybody is with one another, we are with the court and with the law firms. There's not a problem at the end of the day that could cause litigation or anything like that. And there really never is, and that's because of the way we do business. Um, the one other thing that I do, maybe it's a paranoid lawyer in me, but I also make sure that we have recorded phone calls with our customers before we pay them the money and we just go through the terms of our transaction and make sure they understand, make sure we're dealing with the right person. And that way we have that as well. And I think that just protects everybody in the process too.
And can
Uh,
multiple beneficiaries get an advance from Probate Cash?
they can and they often do, as you can imagine. Once one beneficiary receives some money, they tell their siblings, "Oh, I've got money." Sometimes they do, sometimes they don't. But and since we've already actually done our due diligence on the file, if another beneficiary in that same estate wants an advance, we can usually make that advance same day to that person. One thing I just also wanted to go back to is how does the advance affect the probate case? Because again, the folks on this call are sensitive to having to deal with a pain in the neck situation, right? So we do file, as I said, the assignment with the probate court, but it should not affect you guys at all. It shouldn't prolong the case in most instances, except maybe in California. For you California lawyers, there's a probate code right on point, which I think we will get to. It's 11604.5, and that does require you as lawyers to include probate cash in the petition for final distribution.
Okay, well, actually, speaking of it, because you just mentioned it, what are some of the laws that govern inheritance advances?
Sure. So California, that's the 11604.5. That, as you can imagine, for those of you in California, you can look it up. It's in the probate code. But you can imagine it's a very consumer protection oriented statute. It's there to make sure that the heirs understand what's going on. The judges have discretion. They review the assignment. They make sure they have discretion to strike it down. They have the discretion to say it's not fair enough or make sure everybody understands it. But the courts are very used to these assignments in California, as are a lot of lawyers. The Utah also has a fairly new law, 75-3-918 of the code. Pretty much mirrors California with a couple of exceptions. And now coming up is Washington State is about to have a statute as well that is very similar to California. So we love the laws. We love the consumer protections in the law. We want to make sure everybody is on the same page throughout the probate case as it comes to assignments. Like the fact of the matter is, beneficiaries need money, and yeah, they're shocked at how long it takes. They need it for their life's necessities, and that's why they're finding us, and that's why this business exists. We do over 100 of these probably a month throughout the country to kind of give you an idea of how many people are contacting us, and they are contacting us. They're almost all of them are where they're asking us for the advances. So that's the California, Utah, and coming up in Washington law, and that it just makes everything go much more smooth for all the parties, including y'all, the lawyers.
Wow, I think we're already past that 15-minute mark. So, as promised, Mark, you're going to stay on to answer some questions. But if you need to leave now, we'll send everyone a link to the recording of the presentation and the questions and answers. And I also, if you want to ask questions offline, you can call Mark at 561-476-0018, or you can email him at Mark, and that's MARC, at probatecash.com. So, let's get to your questions. Okay, first one is, I represent a plaintiff who's challenging their heirship. Do you make advances in adverse cases?
That's a good one. And yes, we do. It's something that we certainly need to discuss with you, the lawyer. We need to look at the case. We understand the challenges of the adverse cases. If you're representing the plaintiff who's challenging a will or a defendant who's being challenged. But we are willing to and have made many advances in those adversarial cases. So we're that's when you want to call me. So and we'll talk about how to go best about that.
Okay, another question here is, the real estate market is going crazy. How does that affect probate advances?
Yeah, the real estate market's always going crazy, right? And sometimes crazy good, and sometimes crazy not so good, depending on if you're a buyer or a seller. But since that's the primary asset of the estate, that's what we're looking at the value of that property to determine the anticipated inheritance of each beneficiary. So we're looking at it, as you can imagine. We're not, as I said, we're not looking to purchase the entire inheritance. So we're pretty conservative. We look at see what the housing the houses are worth, just like anybody else would, and then we even put a little haircut on that as well. So just to be more conservative with the market and the condition of the house is going to certainly affect the probate advances.
Okay. Now let's see. This one says, as an attorney for the estate, can I be held responsible if I talk to your company about an advance or if you don't get repaid?
No, as I said, these are non-recourse, and you as the attorney, you're not in contract with us. We do want to talk with you. We want to ask you questions about the estate, and we know that you're referring folks to us as well to help out. But no, if I were asking lawyers or paralegals for their reps and warranties and said, "All right, I'm relying on this," I don't think I'd get any help from anyone. I know that I would be reluctant as well. So no, there's the only time there's any kind of liability is when our customer takes their inheritance and doesn't pay us back. That's the only time.
Okay, the next one is looks like it's about referrals. If I send a referral to you, what's the process? Do they just send to your website or what?
Okay, so if you're following your own marketing dollars, you don't want to lose somebody who's about to retain you because they're looking for a fee to pay you or however it may work. If you want, you can immediately call us, even with that person on the phone. You can take some of our applications and have them call us. You can just refer them to us and tell them, Attorney John sent me. You can call with them as well, and our folks will ask the questions about again, if they haven't been retained yet, if they haven't retained you yet, we're going to be looking at the real property. If you have been retained and beneficiaries are asking you since the probate case is opened, you send them to us, and depending on where we are in the case, that we can provide a pretty quick advance, and that's where that could help to repair a home for sale, pay taxes, or just take some of the pressures off of financial pressures off of beneficiaries who were unfamiliar with the whole probate process and need money now.
Great. Let me make sure. I think we got everyone's questions, but I want to double check. Looks like we did. Now, if you're like me and you think of something right when you get off this call, I'm going to give you Mark's contact information again. So, like I said, we will be sending out a follow-up email and a link to this webinar, but you can also call Mark directly at 561-476-0018 or email him at Mark, and remember that's MARC at probatecash.com. Oh, you know what? I think we just have one question. I think we already covered it, but it says someone that wanted to ask again about the referral fee procedure. Um,
Sure.
so if we want to touch base on that one more time.
The referral fee, different than just
Yeah.
referrals. So, okay.
Yes. Thanks. Yeah.
So we will pay referral fees based on the percentage of the advance that we're paying. So if we're making a $10,000 advance, we'll pay some percentage there. We can do it in a couple of ways where we pay a smaller percentage up front when we make the advance, or a larger percentage when we actually get the repayment of the advance, as you can imagine. So again, yeah, call, email me, and we'll go over the terms of the referral fee program. And we get those from realtors, lawyers all the time.
Great. I think that is our last question. And again, just you can call Mark at 561-476-0018 or email him at MARC at probatecash.com. And thank you everyone for joining us and have a great day.
Thanks.